lawyers we speak to, that nobody wants to talk about compliance. Nobody wants to listen to them talking about compliance because the business teams want to get on with business. So I know it's a tough task, but let's try. So here, one thing which I would first like to say is that compliance is not something which the legal team alone can do. It's something which we need to bring the whole organization along with us. We need to ensure that the business teams are on board, the management, the board, everyone recognizes the importance of compliance within the organization. And recently, in fact, I was told by one of the companies I was advising that legal team is looked at as a cost structure within the company, and the business teams are the ones who bring in the big bucks. So nobody pays attention to the legal team for that reason as well. So that's one thing to really, really drive home, that employees at all levels need to be involved throughout the compliance process. And individual employees' conduct can also get the company into a lot of trouble. Mr. Dhal mentioned about it, Ravi mentioned about it. The Competition Commission of India is a growing organization. It's young, it's very active, and it's now becoming more active. So we've seen over the past few years how the enforcement evidence collection by the CCI has changed drastically. There was a time when we started working with the Competition Commission and we would get notices from them, can you please provide us 1, 2, 3, 4, 5 documents? We would provide it to them, the company would reluctantly share some details, would withhold some details, and all of that would go to the commission as responses by the company. What they do now, things I'm talking about in 2015, 16, how they've evolved. They've been writing to Gmail, they've been writing to Yahoo, they've been writing to email service providers, telecom service providers, because they want a record of your emails. They want a record of how many calls you make to a particular phone number. When there was a tender, did you write to somebody talking about a particular tender and what you want to bid in that tender? Did you have excessive number of calls to that individual? We've seen in a very recent case, one email has been misinterpreted by the CCI. It was meant to be an internal email telling your boss that, hey, look, I won the tender, I did a great deed for the company. And look, we made so much profit. But the way it was worded, the CCI has read it as meaning, hey, look what I did. I managed to get a tender along with our competitor. So much profit for the company. And the CCI has now penalized that company because one individual who holds a very senior position within the company wrote that email. So I've already said this initiative. The level of seriousness within the organization for compliance would also be very, very, very heightened. It should be a top-down approach. And this is not to scare you, but here are some of the numbers on the penalties which the CCI has imposed. A lot of them are being challenged, but they were all in the news. They were all splashed on the front page of Economic Times. Everyone in the business community would read these as big fines, and the cement manufacturers is something which we are all aware of. The car manufacturers, Coal India, DLF. I'm moving obviously from the higher fines to the ones which are lower, but this is how the CCI's practice of fining has also evolved. The 1 lakh fines were the first few fines that they'd ever imposed. So you've seen one consequence of a violation would be a penalty. Of course, the legal expense, because you would have to have good advice, and good advice is at a price. And reputational loss, of course, because that's something which is going to be all over the newspapers. And also, if you're a listed company, there's another battle to be won there, because this is going to impact the stock value as well. We'll have senior management from a company involved in the defense, why the company which is being investigated should not be held liable. So diversion of the management time. Perhaps if there are well-regarded and well-informed customers or suppliers who read about these activities, they may also pull away some of the business. And one other aspect which you should be cautious about is the compensation level. The CCI has not yet, the Competition Appellate Tribunal has the power to award a compensation to any individual who's able to show a direct damage from the activities of a company. Now, the CCI has passed several orders. They've been in appeal with the Competition Appellate Tribunal, the Supreme Court of India as well. But there's no compensation that has been awarded yet. But it's only a matter of time because cases are now being decided by the Supreme Court as well. So reputational damage being one of the primary ones and penalty as well being one of the primary ones, because yes, the CCI will also be conscious of things where if they find that there is another violation or another investigation, because it doesn't take much to file a complaint with the CCI. It could be a customer, it could be a competitor, it could be a supplier. If they notice a behavior which they would want to alert the Competition Commission on, it's not very difficult. There's an information which has to be filed and anyone can file it. And the CCI would then hold a repeat offender tag if they've already found you guilty once. And that's happened in a recent case with the cement manufacturing companies. So why does a formal compliance program help? I think this is everyone's, everyone knows that we need to do this, but it's not going to be a sure shot. We have a compliance program, we are not going to make mistakes anymore, but it puts a structure within the organization. It makes it a more formal framework within which an organization has to function. It makes the employees also have a direction that we cannot do certain things, we can do certain things, and when they see something going into the territory of cannot, it helps in early detection of any violation. And why would an early detection help? The CCI has whistleblowing provisions. If you notice any cartel activity, there is a leniency provision there. You could also consider if it's a corrective action that has to be taken with the help of a customer or supplier. You could have in fact, you could become a complainant to the CCI. As I mentioned, anyone can file a complaint. If you see there's a behavior which needs to be taken up with the CCI of a supplier or a customer or a competitor, this could be the opportunity. And in general, it may help in mitigating penalties imposed by the CCI. There's only been one instance so far where the CCI has recognized that a company has a compliance program. Whether it impacted their decision of reducing the penalty is uncertain because their orders are not fully clear on the reasons why they are imposing a particular penalty, but they have recognized it. So there's hope. And there's a global debate on as well about a compliance program being used as a mitigating factor, that are the companies using it as a facade that we are compliant because we have a competition compliance program, which again comes back to the topic that we need to make it a system within the company. It has to be a formal compliance which is checked, reviewed thoroughly over various months, years, whatever it takes. And how do you formulate that? So it's not a one-size-fits-all. It would really depend on industry to industry. What is your market share? What kind of products do you need to focus on? Are you facing the customer directly? Are you facing various competitors in the market? So all of these different angles have to be looked at before telling us employee that, look, you cannot do this. Because sometimes things may not be relevant to that employee. So one size fits all may not work. And yes, I've said this before, but it's not going to guarantee a prevention, but it ensures that there's a vigilance mechanism within the organization which will help detect the violation sooner. And you cannot become the legal team which says, you can't do this or this or this, because the question will then be, what can I do? So it has to be a midway path, and it's something which we can find, because competition law is not saying that you don't do business, but you do it in a certain way if you're dominant, you do it in a certain way if you're not. So these are some suggestions which I've just put together, just some suggestions which you could consider for an internal compliance program. Firstly, I've already said that the support is required from the board or the senior management. So if you have a compliance manual in place, perhaps start with the senior management sending a message to the organization. If you have an offsite where everyone's going together, including the management, start with a keynote speech that, this is something the board takes very seriously. Maybe put in an approval procedure before taking big business decisions. Something where a particular individual within the organization is responsible for ensuring compliance. A compliance committee could be set up. It could be the legal team as well as XYZ individuals who are aware of various different laws, because compliance is not just competition law. It also means various other compliances like corruption, bribery, which I understand will be spoken about after this. But all of those key compliance measures can be looked after by a particular committee. Educating and training the employees is critical. Who are at risk? So that's key. When you have a sales team going into the market and speaking to competitors, we have to be careful. When you have a particular team going to bid for tenders, what are they doing? You have a team attending trade association meetings. Who's approving the agenda for that trade association meeting? Is there somebody looking at what is going to be discussed during that meeting? So the individual is allowed to attend the meeting or not. A manual is the basic least, which is easy, low-hanging fruit, and do's and don'ts as well, which would guide the daily activities of the teams. Something which is handy. And a document creation and retention policy, I would say, is key. So this again, I come back to the CCI's investigations as well here. They have been faced with situations where companies say we don't have a particular document. We don't have X document because we didn't retain it. We just got rid of it. And that's a key document for the investigation process. So if you have a document retention policy which is very clear that, okay, for 7 years or 8 years, which is usually the norm companies have been following for taxation purposes, if that's set in stone within the company that we are only going to retain our documents for X number of years, we have something to go back to the CCI with. We have something to go back to authorities with, that this is a policy which we follow and it's not there. So document creation and retention policy for creation also, you have to have an internal mechanism in place where you would tell your employees that they should be careful of what they write. This is something we call the Economic Times rule perhaps, which is don't write anything in your internal documents or emails which you don't want to see published in a newspaper. Something which will embarrass you later, don't write it. Again, here, so these are various ways in which the statement of the board could be used to emphasize the importance of compliance. And one additional suggestion here that I've got is of disciplinary action. If within the organization there is a disciplinary action which is going to be taken against an individual, that would be a deterrent for them to be conscious and to pay attention when the training sessions are going on, that they're not supposed to do certain things. And they should report to the compliance officer or a compliance committee, which could be under a direct reporting of the board to up the level of seriousness. So here we have a compliance officer, if you see on the image. And yes, I think it may be something which you need. When people need to know who's the compliance officer, they need to go to that individual and say, look, I have a problem. what do I do? And that person should be their go-to, who will be trained by your legal team or who can be somebody who's aware of the procedures. But it has to be somebody who people can easily access, people can go to without thinking, what is he going to think about it if I tell him that I did this? So have that in place as well. A compliance manual, one key thing to remember again is it should be simple. If they can't understand it, if your team cannot understand it, if it's not easy for everyone to refer back to, it's not something which they're going to be able to speak. So it has to be the language that they speak. It has to be made in a way that they are able to understand, comprehend, digest, and make sure they've got it in their system. So easy English with examples. It should be obviously relating to your sector, because it would help if you have examples of violations that you can perceive. For instance, if I may give an example from the petrochemical industry, where there could be issues in discounts. So those are things which you would ideally put in your manual, so that people who they want to look at the manual and look at it and say, okay, if I'm dealing with this, I shouldn't be doing that. If I'm dealing with this situation, I shouldn't be doing that. So those are examples which one can put in to also generate interest. In cement industry, the biggest problem one could say is, yes, am I going for a trade association meeting? So your compliance manual can put a checklist there. I'm attending a meeting, I should probably check 1, 2, 3 items off the list before I attend that meeting. Yes, monitoring is vital. You can't let a slip happen anywhere, and it's key that you have a periodic assessment, and one step further maybe would to keep a record of these periodic checks. If we're doing an exercise and we record it, at a later point in time when we need to go back to that exercise and go back to explain to a regulator that we did check, we don't just have a manual, we don't just have these trainings. It's a check which we do as an ongoing exercise. Here are the documents. This is what the first review revealed. This is what the second review revealed. So we have these records which can even be used later as evidence. I finish here because it's not rocket science, but compliance is something which we all need to put into the system and carry on with business as well, not looking at compliance as a no-no or a challenge.